Good evening, everyone, and welcome to the launch of Volume 48, Issue 2 of the University of New South Wales Law Journal. I would like to begin by acknowledging the traditional owners of the land in which we gather, the unceded land of the Gadigal people of the Eora Nation. I pay my respects to elders past, present, and emerging, and extend that respect to any Aboriginal and Torres Strait Islander people joining us tonight. My name is Ophelia Zhao, and I am the Executive Editor of the UNSW Law Journal. In our 50th anniversary year, it is my privilege to open the launch of this issue, a part thematic issue on the dynamics of power within the criminal law. Each launch is a celebration of ideas, collaboration, and the people who bring it all to life. I would like to thank our authors, some of whom which are here tonight, for entrusting us with their scholarship. The Journal is also thrilled to welcome His Honour, Judge Andrew Haesler SC of the District Court. We extend our sincere appreciation to His Honour for being with us this evening and delivering tonight's keynote address. I also wish to recognise our brilliant faculty advisors, Professors Rosalind Dixon and Gary Edmond, and our Dean, Professor Andrew Lynch, a long-time champion of the Journal. We are particularly grateful to Professor Lynch for delivering the vote of thanks later this evening. A night like tonight is only possible thanks to the support of many: printers, typesetters, artists, reviewers, and of course, families, partners, and friends. But above all, it is the editorial board, informally known as boardies, who deserve a special thanks. Their tireless commitment, sharp eyes, and great humour bring each issue to life. Speaking of good humour, the tireless yet generous dedication of our executive committee is the heartbeat of this journal. Our 5 issue editors, forum editor, digital editor, each bring their own brand of brilliance to the table. Over halfway through my tenure, I remain in awe of their wit, warmth, and passionate debate over AGLC rules. A special thank you to our digital editor, Alicia Lau, whose behind-the-scenes magic ensures everything runs smoothly, even when it doesn't. And then there is the person whose issue we are celebrating tonight, the editor of Volume 48, Issue 2, Cordella O'Loughlin. I think it's safe to say that I speak on behalf of the entire journal, as well as others here tonight, when I express my deep respect for Cordella's dedication to the journal, and also my deep appreciation for her constant optimism and support. Although we are very sad to be losing Cordella, we know the journal is now in very capable hands of her successor and my good friend, Dean Chong-Fu. Lastly, launches are an opportunity to thank and recognise the generous contributions of the journal, premier sponsors: Coors Chambers Westgarth, Herbert Smith Freehills Kramer, King and Wood Mallisons, and most significantly tonight, Allens. Our sincere thanks to Olivia Kennedy for her incredible support in bringing tonight together. Allen's invaluable sponsorship means that the journal is able to maintain its status as one of Australia's leading academic law reviews, and for that, we are forever grateful. Thank you for joining us tonight for Issue 48.2's launch. It's now my pleasure to invite Simon Soljo, partner at Allens and expert in financial services law, to speak on behalf of the firm. Can we all please give Simon a warm round of applause before he gives a speech?
Thank you very much, Ophelia, and good evening, everyone, and welcome to Allens. I would also like to acknowledge the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation, and I pay my respects to their elders, past and present, and extend that respect to Aboriginal and Torres Strait Islander people with us tonight. It is my great pleasure to welcome you all to the launch of this edition of the Journal. I'm particularly pleased to have the opportunity to welcome you as a graduate of UNSW Law School, now an increasingly long time ago, and a current member of the UNSW Law and Justice Advisory Council. I think the reason why I was invited to help launch the criminal law edition of the journal this year is not my expertise in financial services law, I hope, but rather my connection to the university, which I'm very grateful for. I would particularly like to welcome His Honour, Judge Haesler of the District Court, who will be delivering tonight's keynote address. The Judge is a respected member of the New South Wales District Court, appointed in 2010 after a distinguished career in criminal law. He began his career at Redfern Legal Centre in 1982 and later served as Deputy Senior Public Defender, known for his strong advocacy and commitment to justice. He has also contributed significantly to law reform and legal education, holding roles in the New South Wales Department of Justice and lecturing widely on criminal law on difficult topics such as sentencing children and the use of DNA evidence. Judge Haesler's career reflects a lifelong commitment to fairness, legal integrity and community service, making him a valued and influential figure within the Australian legal community. And of course, in that same community, there are few partnerships and relationships that have endured with the same consistency and purpose as the one between Allens and the UNSW Law Journal. It's not just a matter of the years that we have worked together, it's also a shared belief in the power of ideas to shape the law and society. For over 40 years, we've worked with the Journal both as sponsors and collaborators in a broader intellectual project. Many of our lawyers began their journeys here, editing, writing, debating, and carried that spirit of inquiry into their professional lives. The Journal has always been more than a publication. It's a proving ground for the kind of thinking that drives legal progress. Each edition brings something new, and this one is no exception. Dynamics of Power within Criminal Law offers a timely and critical exploration of how power operates across the criminal justice landscape. It examines the shifting relationships between key stakeholders, judiciary, lawyers, law enforcement, defendants, and the public, and how these dynamics influence legal outcomes, policy decisions, and reform efforts. Critically, it asks some difficult but necessary questions, and that's exactly the kind of conversation we're proud to support. In a time when criminal law is increasingly scrutinised for its role in perpetuating inequality or enabling reform, this issue invites readers to consider how power can be both a tool for accountability and a barrier to equity. It challenges us to rethink traditional hierarchies and to engage with the law as a living system, one that must continually adapt to the demands of transparency, fairness, and social change. So again, welcome all, and congratulations to everyone involved in this edition, especially the UNSW Law Journal Editorial Board, and Cordella O'Loughlin, editor of this edition, who I now invite up to speak.
Thank you, Simon, for that very kind introduction. Before I begin, I also wish to acknowledge the traditional custodians of the unceded lands and waterways on which we gather tonight, the Gadigal people of the Eora Nation. I pay my respects to their elders, both past, present, and emerging, and extend that respect to any First Nations people present with us tonight. Welcome, and thank you for joining me to celebrate the launch of issue 48.2 of the UNSW Law Journal. The first issue of the journal was published in June of 1975, and so it's an honour to be here launching an issue almost exactly 50 years later. In the foreword to Volume 1, Issue 1, then Chief Justice of New South Wales, Sir Lawrence Street, highlighted the centrality of human nature to the law. That sentiment sits at the heart of issue 48.2. Law, especially the criminal law, is ultimately about people. It regulates relationships between individuals as well as in between individuals and the state, and is meant to reflect and to respond to society's moral values. When exercised appropriately, the power of the criminal law can help ensure peace and civility. But when misused, it can entrench power imbalances, inflict harm, and ultimately fail to deliver justice. This is particularly worrisome where the consequences can include a person's loss of liberty. This is what led me to the theme of dynamics of power within criminal law, as a way to highlight these instances of injustice and encourage discussion about how such power can be more justly managed. Issue 48.2 has done just that. Although she unfortunately couldn't be here this evening, Carly Warner's forward opens the issue by reflecting on the work of the Aboriginal Legal Service and the role of movement lawyering in challenging the systemic injustice Aboriginal and Torres Strait Islander communities face. Lizanne Adams' article interrogates the coercive Mr. Big investigative technique and the extraordinary power it grants police over individuals. AJ George, Vicky Lowick, Nicola Corbett-Jarvis and Emma Turley examine the power dynamics that shape sexual assault trials in their consideration of Scotland's juryless trial pilot. Ingrid Matthews and Nigel Stobbs reflect on the ongoing influence of patriarchal norms in affirmative consent reforms. Christopher Rudge gives a voice to the silenced welfare recipients who are wrongfully convicted in what he describes as the omissions affair. And Lisa Billington examines France's use of colonial criminal law against Kaneki's Indigenous independence movement, drawing unsettling parallels to the treatment of First Nations people in Australia. Together, the articles comprising issue 48.2's thematic component illustrate the many ways criminal law can and has entrenched power imbalances, intentionally or otherwise. Of course, detrimental power imbalances are not only confined to the criminal law. As always, the articles that make up the general component of issue 48.2 speak to these broader issues as well. Esther Erlings and Laura Grenfell explore the complex legal landscape of social care detention and the potential injustice it creates. Katrine Delvilla, Ruthie Generette and Ben White examine the barriers faced by patients seeking voluntary assisted dying. Angeli De Silva and Christine Parker investigate how social media has the power to amplify gendered hate speech. Naomi Burstanyar and Genevieve Grant offer an empirical profile of coronial litigation, providing a grounding for deeper analysis of power dynamics in such cases. And Neera Bhatia and Julian Copland conclude the issue by considering egg donation laws, arguing for compensation models that empower rather than exploit donors. The diverse contributions to this issue reflect exactly what I had hoped for when in choosing this theme. That is, they A, highlight the many different power dynamics that are present within the criminal law and our legal system more broadly, and B, provide a forum for conversations that centre on the people most negatively affected by the law. I am so grateful to the 21 authors who entrusted us with their work in this issue. It has been a privilege to work with each and every one. In particular, thank you to Ingrid Matthews, Christopher Rudge, Lisa Billington and Esther Erlings who are here this evening. I encourage you all to take a moment to speak with them if you get the chance about their insightful articles. I joined the Journal at the end of my first year of university, drawn to it as a student-run publication committed to high-quality legal scholarship. I had no idea then how important it would become to my university experience. While editing can be a solitary task at times, the camaraderie of our self-named boardies, especially at our Super Saturdays or events like tonight, has made my time on the Journal deeply rewarding. I'd like to thank each of you boardies for your diligence in bringing issue 48.2 to publication. Every one of its 378 pages owes its accuracy to your sharp eyes and dedicated efforts. This issue would simply not be in your hands tonight without your hard work. While we do pride ourselves on being a student-run journal, our continued success is thanks in large part to the support of the UNSW Faculty of Law and Justice. In particular, thank you to Professors Rosalind Dixon and Gary Edmond for your continued support and steady guidance as our faculty advisors, and to Professor Andrew Lynch, the faculty's dean, who has long been one of our greatest champions. Our premier sponsors, Allens, Herbert Smith Freehills Kramer, Cause Chambers Westgarth and Kingerwood Mallisons, also make our work possible. In particular, thank you to Allens for hosting us here this evening and to Olivia Kennedy for her efforts in organising the event tonight. I'd also like to offer a large thank you to my family and friends for their love and patience over the last 14 months. At the launch of issue 48.1, Andrew remarked that it can't be easy to live with an issue editor. I suspect that's been quite true in my case, and so I'm incredibly grateful to all of my friends and family for sticking by me throughout it. Another group whose support I've been very lucky to have is that of the Executive Committee. I've been very fortunate to work with some incredible people across 2024 and 2025, and can say that I have made some truly lifelong friends in the process. Thank you very much to each of you for being quite invaluable supports to me. Returning now to Sir Lawrence Street's foreword, His Honour wrote, quote, "I am delighted to participate by writing this foreword in the confident anticipation that in the years ahead, this journal will justify an established and respected place amongst our Australian legal periodicals." Well, I think we can all agree that after 50 years, his confidence was well placed. It is now my great honour to introduce our keynote speaker for this evening, Judge Andrew Haesler. His Honour studied law at UNSW, was admitted in 1981 and began his career working at the Redfern Legal Centre, the Aboriginal Legal Service in Alice Springs, and the Legal Aid Commission in Wollongong. His Honour was called to the bar in 1990, where he practised from Hargrave Chambers, while also volunteering at the Illawarra Legal Service and teaching at the University of Wollongong. In 1995, Judge Haesler was appointed a South Coast Public Defender and later Deputy Senior Public Defender. In 1999 to 2000, His Honour served as the Director of the Criminal Law Review Division in the New South Wales Attorney General's Department. He was appointed Senior Counsel in 2004 and a Judge of the District Court of New South Wales in 2010. His Honour now serves as the Permanent List Judge at Wollongong and is a recipient of the UNSW Alumni Award for Community Service. Thank you, Your Honour, for delivering our keynote address this evening. Your impressive career overwhelmingly qualifies you to speak on the theme, and I know we are all eager to hear from you. Please join me in warmly welcoming His Honour.
It's important that we do, as the previous speakers have done, acknowledge the custodians of the land and the place upon which we meet, where we gather, its history, the history of this place and the people who have occupied it since forever. It's important that we reflect upon that long history. I was planning to come tonight as a guest. I was visiting the University of New South Wales today to sit in with some students who have a very difficult expert evidence task next week. I had no previous connection with 48.2, and I agreed to fill in place of the intended keynote speaker, who has made a contribution to the journal. When I agreed to speak, I had not then read the journal, nor was I aware of what Carly Warner, the anticipated keynote speaker, had written. Now, I want to confess at the beginning of this talk that unprofessionally of me, I feel just a little bit uncomfortable. Now, I am accustomed to public speaking, and as an ex-legal aid lawyer, I'm actually accustomed to public speaking for free. So you may ask, what has an old white judge got to be uncomfortable about? Well, let's start with Ms Wagner, or Carly. She is a young Palawa woman and the chair of the National Indigenous Legal Aid Service. I am none of those things. Then there's the theme of the journal, issue 48.2, power dynamics within the criminal law. I have absolutely no hesitation in guessing that Carly and I would have different practical experience of and perspectives on those dynamics. So what can a male, stale, pale judge say instead of an FWT? First woman too. And there are many of them in the Aboriginal Legal Service, and I've met many of the first women too in my long career. My immediate response as a stale, male, pale judge was to take what Carly had written and say a few things that might add to what she develops in her foreword and on the general theme of power dynamics in the practice of law. But after quiet reflection, I thought, hang on, isn't that just the sort of thing that a stale, pale male would do? And as I read the articles, I added, What else would you expect from a privileged patriarch who has benefited from the very status quo his position continuously consolidates? It is not my place to mansplain Carly's forward. Carly's words speak for themselves. Read what she says and reflect on them. It is not for me to put a gloss on them. But her words, along with the other contributions, have caused me a degree of discomfort. And that is a good thing, about which I'll say more shortly. But first, can I offer thanks and congratulations to the authors for the hard work they've put in, and give particular thanks and plaudits to the editors. It is not an easy task, and I am sure there have been trials and tribulations along the way. My own experience as an editor has been limited. At University of New South Wales, I was what a number of deans called an activist student. In other words, an irritating pest. But my skills were not those needed for the journal. I did once put the red pencil through a dear friend's manuscript prior to publication. After that, silence. When the book came out, along with the usual dedications to family, friends and contributors, was this short line: to Andrew Haesler, who sacrificed friendship for truth. Sadly, our friendship is still not what it was, but frankly the book was better off for the revisions that I had suggested. Cordelia, you will have to live with the one line in 48.2 that is in error. It cannot be corrected. It is there in print at 377. I am sincerely grateful to Carly for her engaging forward that begins issue 48.2 and for delivering an equally insightful keynote address at the issue's launch. Next week, no one will notice. You will lose no friends over that unavoidable error, and I hope I can reduce the extent of the error by offering some of my own insights. Carly's introduction reflects on the role lawyers play in helping the powerless, helping those directly impacted on by injustice to take on those who exercise power against them, pursuing justice by enabling and uplifting those most affected by injustice, she says, will always produce greater fairness and equity for everyone. She gives an example from the early days of the Redfern Aboriginal Legal Service in the 1970s, early 1970s. In response to unfair, systematic and racist action by New South Wales Police at a popular Aboriginal pub, the Empress, volunteers from the profession and the law schools were recruited to attend and monitor the actions of police, particularly the notorious 21 Special Squad. Policing the police, surveilling the surveillors was the motto. I lived nearby. I was an enthusiastic recruit and went along. And in particular, the paid lawyers shouted us students a beer or two. This action was directed by Aboriginal people, and it led eventually to the establishment of the first Aboriginal Legal Service. I was young and I had been an industrial worker and in the workforce for a while, not naive, but I was very inexperienced in dealing with police. I was not an experienced drinker. After one beer, I was useless to monitor anyone, let alone actively intervene to prevent their police's heavy-handed treatment of the local population. I had no power, no authority, and was operating on a number of handicaps, one of which was self-inflicted. Confident of their authority, such police actions continued against the people of Redfern for years, until the 21 Special Squad was eventually terminated by the then New South Wales Rand government in 1981. But that government had been in power for many years and had tolerated the actions of the 21 Special Squad. That tolerance was in large part required because of the power the police force as an institution exercised and frankly still exercises in this state. Much needed changes were delayed and obstructed. The obstruction included a police strike on enforcing criminal laws in the electorate of the Attorney General, Frank Walker. The reform process was subverted. The Summary Offences Act that the police were so upset about eventually came in, but it resulted in more, not less imprisonment, as Matthews and Stubbs note in their article in the Journal. Police attitudes in the 1970s were exemplified by the actions of the 21 Special Squad, not just towards the residents of Redfern. because soon after they were brought to prominence by their attack on the first gay Mardi Gras. Not many years later, when as a solicitor I questioned similarly heavy-handed police action against demonstrators in a place not very far from here, the Wentworth Hotel, I went up to a senior police officer and questioned his directing police to illegally detain a large number of student demonstrators. He turned to me when I questioned his authority and simply said, "I have 200 police here, son. I don't need authority." And that attitude continued up until, I suspect, the Police Royal Commission. Carly's foreword starts by seeking to put some theory and definition into what many progressive lawyers, and I count myself amongst their number, have been attempting for the last 50 years. That is, to use the legal system and our skill as lawyers to protect the powerless and advance their interests. She speaks of it using the term, which was not familiar to me, movement lawyering. Lawyering that supports and advances social movements, defined as the building and exercise of collective power, led by those most directly impacted to achieve systematic institutional and cultural change. She notes later that movement lawyers must, quotes, use the full range of tools available, including litigation services, legal policy, grassroots outreach, education and organising. Now, for me, the challenging and uncomfortable aspect of that definition is not how lawyers use their skills and the tools available to them to help the most underprivileged in our community, but the bit about being led by those directly impacted. In my experience, lawyers want to run things. They are aware of the power they hold and they want to exercise it. They give advice and they expect that advice to be acted on. They take on a client, they act on instructions, but they run the litigation. How then do lawyers working with movements seeking social change deal with being led? As Carly notes, it is incumbent on lawyers to continuously reflect on the institutions and processes of the legal system and their role in it. Now, for obvious reasons, my perspective is skewed, not just by my present role, but my experience that started at UNSW in 1975. As a law student, I was involved with the setting up of the first community legal centre. It opened in 1977, Redfern Legal Centre, just round the corner from the ALS. In 1977, I was horrified to find, in preparing some submissions for the Naval Royal Commission, that over 3,600 people were held as prisoners in New South Wales Jail. 260 of them were Aboriginal and Torres Strait Islanders. Sentencing judges at the time were lauded for their harshness of their penalties and lampooned for their old-fashioned ways. Now we like to think of ourselves as relatively more benign, but our sentence judgments, while more considered, technical and less emotional, impose significantly harsher sentences now than then. Redfern Legal Centre was actively involved in the local community, but it was not led by that local and very diverse community. We provided a walk-in service and developed strategies based on our perception as lawyers and law students of what was needed to meet the legal needs exposed by those seeking our help. I later worked as a solicitor at Redfern Legal Centre, and my focus was on representing tenants seeking fair leases and advocating for the protections of a Residential Tenancies Act and tribunal. I also spent at least one day a week providing advice to prisoners inside jails. On any scale, prisoners are among the most powerless in our community. And while I worked with the Tenants' Union and I worked with the Prisoners Action Group, I was not led by them. Frankly, if I had been led by the Prisoners Action Group, my practising certificate would have lasted about a week. They had very little respect for the processes of law or the ethics of the legal profession. But then I went to Alice Springs to work for the Central Australian Legal Service. There who I acted for, and what I did as a lawyer was directed by the Carless board. I was comfortable with that. The board had the knowledge, They were made up, democratically elected, of traditional owners from across the bottom half of the Northern Territory. They exercised their powers in the same way a corporations board would to direct employed or contract lawyers. I did some very dull but essential work setting up the legal structures for the Papunya Tula Cooperative, which marketed the first of the dot paintings, some of which expensive art I could never afford, but which I noted is dotting the walls of the building where we are gathered today. I worked as a duty solicitor in remote regional courts, and I took on appeal cases that challenged heavy-handed policing that sadly continues to this day. The board did not interfere with my professional acting for clients, but they certainly governed what I did and how I did it. Then, in the way of democracies, there was an election to the Carless board. The new board had a strong country Liberal Party presence. They had different ideas than the previous one about the services we provided. They immediately passed a resolution, and we're talking about an Aboriginal legal service in the early 1980s then, that said no Aboriginal legal service lawyer will act for an alleged offender if alcohol is involved in the commission of the offence or if they are guilty. When I questioned that directive, and particularly the one about if they are guilty, they said, "We know, we'll tell you." Soon after, I went to Papunya in the Western Desert to do the list. In those days, you drove out with a field officer and a Land Cruiser full of locals hitching a lift home for the sittings. You would stop outside the reserved area to ensure that there was no alcohol in the car, because if it was, the police would search it and confiscate the car. You would then shoot some kangaroos, non-PC, but absolutely essential because we provided meat for the old people as part of our visiting obligations. It did lead to me once, the only time in my career, being able to say to a magistrate, "I tender this blood-stained document," because they had dumped the dead kangaroo on top of all my gear. But I digress. You would sleep on a clay pan outside the local visitors' hotel. There were 3 rooms. One had working air conditioning, one had a working toilet, and one had a working fridge. We slept outside. There were 100 cases in the list, and according to the board, I could act for 2 of them. I acted for them all, and on my return to Alice was smacked. I was immediately reinstated, as in my absence they had sacked everyone else in the office. Now, the board's actions were probably contrary to Carless's charter, and they were certainly contrary to the funding arrangements they had with the Commonwealth Government, which involved acting for every Aboriginal person charged with an offence. But who was I to make that call? I refused to be led by a board made up of traditional owners, properly elected, exercising their own sovereignty in their own country. My refusal on one level rejected their exercise of power as directors of an incorporated organisation, a power given to them by colonial law, but exercising powers as part of their community that went back to time immemorial before colonisation. I was an arrogant, ignorant white lawyer. They were right to sack me. I was not prepared to be led. Now, I consoled myself by asserting my personal right not to perpetuate what would now be called a carceral response that would have left the people of Papunya before the court without someone to represent them and prevent them going to jail. Was I wrong? I returned to become the senior lawyer and coordinator at Redfern Legal Centre. I assumed a burden that has followed me through my life of taking over from a woman called Virginia Bell, who went on to other things. After I left Redfern, I worked primarily as a defence lawyer. I appeared in hundreds of trials and appeals. The perspectives of power generated by that role govern my thinking and perspectives to this day. It dictates how I respond to challenges to fundamental questions, particularly when the question is asked, what is a fair trial? A fair trial for an accused may be seen as another example of patriarchal oppression of victims of crime. An unfair trial can be an example of unfair oppression by the settler state to an accused, particularly an Indigenous accused. Frankly, a fair trial for a judge is one that moves smoothly and efficiently without me having to actually make any decisions, but that's a personal perspective. The articles in 48.2 raise some of those difficult perspectives, and as they should, challenge the status quo, and thus challenge what I do every day as a trial and sentencing judge. That is a good thing, but can't help from being uncomfortable about the criticisms inherent in some of the articles. I have to act as a gatekeeper to the admissibility of evidence. I have to govern how evidence is presented and in particular tested. Interests must be balanced, but balance is again dependent on perspective, which is in turn subject to my own cognitive biases, perceived or unconscious. The contested sexual assault trial, which is referred to in a number of articles, tests every participant in it. As a judge, my preliminary rulings about what is both relevant and admissible set some parameters. A judge is applies to try and reduce to the most basic level for a jury the complexities introduced by the repeated attempts by Parliament to legislate fair laws and address the competing ideas about what fair is. Journal 48.2 raises and challenges some of these points. First instance judging cannot remove the risk of unfairness, and some rights of individuals involved are in direct conflict. The best we can do, and often the best is not good enough, is to try and reduce harms caused by the stresses of a court appearance and the current and deeply flawed assumption that harsher punishment is the answer to social ills. There are obviously a number of power dynamics in a criminal trial. It is, in my view, the least worst option we currently have for determining if a person who is accused of transgressing our laws and does not admit that fact should be punished. The flawed but fundamental premise of a criminal trial is that we are all equal before the law. This concept has never been better criticised than Anatole France in 1894. In its majestic equality, the law forbids the rich and poor alike to sleep under bridges, beg on the streets and steal loaves of bread. And it is the fact of harsh punishment after conviction that underpins Blackstone's oft-repeated comment about it being better if 10 guilty go free than an innocent man be convicted. It's the fact of punishment that is critical to that important aspect of our criminal justice system. And while the focus is on punishment, it is important that only those who either admit or are found guilty be punished by the state. An accused person at a trial sits in a dock. A state prosecutor who has some support of a police investigation presents the state's case against him. Both the accused and any complainant are thus subject to state direction and control. As a trial starts with a presumption of innocence, its corollary is that the complainant's accusation is, at one level, unprovable or at worst, a fabrication. The continued health of our jury trial system requires continued testing of those propositions. It may involve, challenges to a complainant may involve exaggeration of their frequency, but false allegations are sometimes made. Complainants do not always have excellent memories. And I know the journal focuses on appeal cases, but a case of mine, coincidentally called Allen, and no relation to the founders of this firm, brought that home. It was a case involving, it's reported in the 2024 reports, of two twins who said they were sexually assaulted by their grandfather nearly 50 years earlier. There was tendency evidence. There was an abundant amount of evidence to show that the grandfather had abused them. The girls now women had not got their heads together, as was obvious. They both described an incident where grandfather abused them at a certain location. That's where the comparisons stopped. Their versions of events were so different. I had no hesitation in accepting that something happened and something was done to them by the grandfather. But I couldn't find the elements of any offence proved because those two versions were so contradictory. There was another child, I found him guilty of that, I might consult people, but it was an example of how memories are conflated. I often have cases where people admit their guilt, and you see particularly a child's complainant's version of events, then you have the adult who perpetrated the offence, and the adult who makes those admissions contains a lot more detail, a lot more crime often than what was initially revealed by the child complainant. So there are no direct rules that can be laid down. What some might characterise as myths might be others' personal experience. We are, as a court, trying as best we can to embrace, despite the 18th century costume, 21st century technology. I do wish that we'd voted for a government that gave us something better than the shitty NBN that we have to put up with, but we do our best. Of course, more can be done, and we are presently experimenting and trying out new techniques. Sometimes I have been singularly unsuccessful in preventing defence lawyers badgering witnesses, or at times prosecutors. There is only so much that Section 41 of the Evidence Act, which allows a judge that power, can do. But the power dynamic is not all one way. And most cross-examiners do not demonstrate the verbal acuity presumed of them by one of the articles in the journal. If I can give two examples. A young woman subject to extended cross-examination based on myths that were not only old school but positively antediluvian, responded to cross-examination, "I'm a modern woman, I can go out, I can dance." There was a general "go girl" response from the jury. The second was triggered by a South Coast case of a young Yuan man, Queen and Foster, which was referred to in Lassane Adams's article. I acted briefly for Mr. Foster, and I knew intimately the tactics of the local detectives who had a habit of fabricating confessions from young Aboriginal men. Sadly, Foster served his full sentence before he was acquitted on appeal by the High Court. I later represented his co-accused in the burning down of the Narooma school case, Kieran McLeod. Kieran was appearing in Bega Court, and while waiting for the jury and the judge to come into court, he let out some choice words from the doc. A doc, I might add, that was designed, literally as far as I know, with bars and a position in a court to refute the presumption of innocence. The Crown prosecutor seized his advantage and asked McLeod why he was calling the witnesses against him, which for brevity's sake I will reduce to the initials MFCs. He replied, "I did not call them MFCs." When the jury came in, he was pressed. "You called the witnesses in the back of the court MFCs." "No, I did not." "Did you not use the words MFC?" With exquisite timing, Kieran replied, "Yes, I did, sir, but I was not talking about the witnesses. I was talking about you." But I digress. But advantage one, defence. Carly's Forward sets out steps by which lawyers can assist communities in the fight for self-determination. And the editors will soon, if not already, be making career choices. If you want to take up more movement lawyering, I suggest you take Carly's sage advice. There will be tensions. There always are with the dynamics of power. You can, as a movement lawyer, achieve a lot. Redfern Legal Centre in the 1980s was able to achieve considerable success just by being better litigators than everyone else. And we did take on, and sometimes very successfully, the big end of town. But we did have people like Virginia Bell, John Baston and Ben Slade and others working for us. The community legal centres, the Environmental Defenders Office, the Aboriginal and Torres Strait Islanders, have subsequently formed pro bono partnerships with the big litigators to good effect. But in the criminal sphere, including coronial matters, the dynamic is not always accused versus state. It also involves the victims, families and impacted communities. The privilege and burden given to judges is the power to remove a person from the community and deny them their liberty. In my everyday life as a judge, that presents the greatest challenge, particularly in cases involving violence by men against women. It is particularly acute, given my background, when I come, as I regularly do, to sentence Aboriginal men. In 2013, the High Court published 2 seminal judgments on sentencing Aboriginal and Torres Strait Islander people, Bugmy and Munda. Neither, I note, addressed the issue of the impact of colonialism. That particular C word, different than the one used by Mr McLeod, was not mentioned by the High Court. Neither case addressed the critical issue of over-incarceration and its intergenerational impact. In fact, the court in Bugmy said that judges should not be concerned with over-incarceration of Aboriginal offenders. The judgment sought to give parameters for how sentencing courts could give effect to profound deprivation and exposure to trauma. And at an individual level, we are able to do so. The concepts, however, carry internal tensions. As Justice Bell said in Munda, a sentence for a serious domestic violence offence must also work to protect vulnerable Aboriginal women who are frequently subject to abuse. She noted the necessity for courts to ensure that Aboriginal Australians are not deprived of the protection which is assumed punishment provides, and to avoid the perception that serious violence in Aboriginal communities will be treated by the law as a matter of little moment. Appropriate punishment can involve and should involve proper vindication for the victim of violent crime, but for a myriad of reasons, increased jail time is not the answer. A jail sentence often leads to more and longer sentences, and the impact on families of having a parent in jail are not incalculable. We can calculate them. We know it increases the risk a child will come into contact with the police, the justice system, and such contacts lead to jail. An intergenerational consequence arising out of our failure to understand the fundamentals of our criminal justice system. And that's something that's been brought home to me, having practiced in the Illawarra for a long time. I am now dealing with the grandchildren of my former clients. I want to close by reflecting briefly on Carly's forward in the light of issue 48.2's theme, the dynamics of power, and the risk of being accused of being a stereotypical pale male and stale. Give 2 cautions. The first is the dismal failure of our entire community, not just Aboriginal Torres Strait Islander legal services, to address the problems caused by over-incarceration of Aboriginal people. And the second is to prepare for the backlash any success will bring movement lawyers, because there are many in the community who do not want and are prepared to move to ensure there is no change to their status quo. In my time as a lawyer, the level of surveillance of and policing of Indigenous communities that required lawyers years ago to attend the Empress Hotel has increased. Despite the best efforts of a generation of ALS solicitors and other defence lawyers, despite evidence informed suggestions from royal commissions and law reform commissions, our sentencing laws have become more regressive. As I noted earlier, in 1977, when New South Wales state population was about 5 million people, there were 3,680 people in jail. 250 were Aboriginal and Torres Strait Islanders, 7%. The Nagle Royal Commission labelled these figures and the state of our jails a disgrace and proposed measures for change. They were not implemented. In 1988, there were 384 Indigenous prisoners in jail in New South Wales. In 1990, the New South Wales Greiner government introduced so-called truth in sentencing laws. By 1998, there were over 1,000 Aboriginal and Torres Strait Islander prisoners in New South Wales jails. As of July 2025, the New South Wales population is 8.65 million. There are now over 13,000 people in our prisons. Over 4,000 are Aboriginal and Torres Strait Islanders. 32% of the male population and astoundingly 41% of the female prison population. And may I commend Matthew and Stubbs' article on this point. Those are blunt figures. They require considerable analysis. And progressives must reflect on those figures. They provide stark evidence of a failure in our legal system. I remind people, and it should not be forgotten, of the Uluru Statement from the Heart. Proportionally, we are the most incarcerated people on the planet. We are not an innately criminal people. Our children are alienated from their families at unprecedented rates. This cannot be because we do not love them, and our youth language in detention in obscene numbers. They should be our hope for the future. These dimensions of our crisis tell plainly the structural nature of our problem. This is the torment of our powerlessness. A statement on behalf of the Aboriginal people of this country. There are many, many reasons for what has led to that torment, but sadly 50 years of lawyering on behalf of Aboriginal accused in the criminal courts has not prevented those appalling statistics. My second caution draws on trends blatantly on show in the United States of America and sadly emerging here. In a recent article in The Australian, a professional pundit sought to rally defenders of the legal status quo against what she described as brutal progressivism that starts in universities. And she would say that they were exemplified, in her opinion, by the current publication, something the editors should be proud of. This progressivism, she said, required fierce resistance against those who would politicise our institutions of justice, as if they were never politicised. This politicisation was not, she said, the impact of colonialism or prisoner numbers or the community cost of imprisonment, nor was it the commercial focus of our legal institution. Rather, she criticised people who raised questioning stereotypes in rape trials, implied political freedom in our constitution, and any acknowledgement of the original inhabitants of this country, and statement of the simple fact that they never ceded sovereignty, but had laws imposed upon them. Somehow, what many had fought for over generations is portrayed as grim, grey orthodoxy. Miss Albrechtsen was not being satirical. We're now seeing in the United States of America that by labelling improvements to democracy as progressive, enables others to misrepresent what they say or stand for. By fixing a label such as woke, and I fear movement lawyers, critics in the mainstream and online media will falsely define what they stand for, what progressive lawyers stand for, and compare their goals with some utopian belief that things were once better then than they are now. This can lead to a race to the bottom by the very institutions we rely on to continue our democracy, as the current race to the bottom by the executive government in the United States and the Conservative majority on the Supreme Court seems to demonstrate. It will lead opponents of progressive change lawyering up, and as the Environmental Defenders Office found, the opponents of movement lawyering have particularly good lawyers and very deep pockets. No one should be ashamed of being a progressive lawyer. No one should be ashamed of responding to and being led by community institutions. No one should be ashamed of working to improve our legal system. Progress is a positive thing if it is informed and evidence-based. And the role of journals such as 48.2 serve that aim. We must be wary, we must be vigilant, but we must be enthusiastic in our recognition of the faults of our current system and acknowledge ways it can be improved to protect the vulnerable. To return to Carly's forward, it is incumbent on lawyers to continuously reflect on institutions and processes of the legal system and their role in it. So thank you for the opportunity at short notice, to reflect and feel a little uncomfortable when doing so. But the real thanks should go to the editors. Your law degrees will give you enormous privileges, including the right to speak truth to power and to challenge the exercise of power. And you will have opportunities to exercise real power over the lives of others. Your work on the journal will help equip you for that task. So to the boardies and their authors, congratulations. Thank you.
Well, good evening. I'm Andrew Lynch and I'm the Dean of the Faculty of Law and Justice, and it's my pleasure tonight to close us off with a vote of thanks for our speaker, Judge Andrew Haesler. And I look forward to doing that after such an amazing address at short notice. We can only wonder what long notice might produce, but I'll turn to the judge very shortly. I wanted to begin, though, by acknowledging something that Ophelia said, which was that every launch of the issue of an issue of the UNSW Law Journal is a celebration. And I don't think it's much of a secret that I feel that way too. I feel that every issue launch is different in some way, and I made that comment at the recent celebration of the 50th anniversary of the UNSW Law Journal, and then gave some examples of what I mean by that. First and foremost, I think it is a very well-deserved celebration for all the authors whose work is published in the journal, and I congratulate every single one of them, and especially those who are here tonight, really to sort of bask in this moment. I was talking to, not Cordella, but another issue editor whose work will appear early next year about the process of putting together that issue. And of course, it's difficult to get published in the UNSW Law Journal. One is not simply waved in. The standards are very high. The view of reviewer 2 is always a stumbling block for many authors. And congratulations is well and truly earned by those whose work appears alongside so many other impressive pieces. So in terms of celebration, well done to all who are published in the issue tonight. Of course, celebration is also experienced by the team, and it is a team. Whenever I open the cover of the journal and see the long lists of names of all the students who have made it possible, obviously the executive work very hard, but there are so many hands that go into each and every single issue. It's the work of many. So congratulations and enjoy your celebration to all those on the journal team. But as always, there is an issue editor, and congratulations to Cordella on her achievement in bringing this issue of 48.2 down safely for its landing. It's a huge undertaking. And I often meet people when they are confirmed in their issue editor role, and then a year later, miraculously, here we are, and there's a finished product reliably for your consumption, enjoyment, and to provoke thoughts. So Cordella, the mission has been accomplished, and well done to you, and of course, thanks to all those, particularly your family, who have also made that sacrifice. I also want to stress that the faculty's pride in the journal is borne out by the presence of some of my colleagues here to also partake of this celebration. Obviously, the academic advisors, Professors Gary Edmond and Ros Dixon, who for many years now have supported the work of the journal in a large number of ways. Their contribution is something I know that everybody who works in the journal is enormously pleased to have, and the faculty thanks them also. But I'm really pleased to see a number of my colleagues here tonight to also celebrate with our students for all that they've achieved. And so thank you to my friends and colleagues for joining us. Every good celebration needs a good host as well, and so I really want to thank Allens for hosting us here tonight, as well as, of course, their long sponsorship of the journal. Over 40 years in a journal with a 50-year history. That's a very steadfast support. And I really want to thank Simon Soljow as well. Simon is an alum, as he pointed out, but also has been for several years now a member of the Faculty's Advisory Council, where he has close attention to all the happenings at UNSW as well. So it's a real pleasure to also be welcomed to Alan's, particularly by you, Simon. So thank you. I now turn to our speaker tonight, Judge Andrew Haesler, and Andrew began his remarks by being very clear that he was not Carly Warner, and I think that was well understood. But as I was listening to him, and much as we miss Carly being here tonight, I do feel we're the unique beneficiaries of a 2-for-1 deal. We do have a magnificent forward to the issue, and we have also had a really great address from the judge tonight, in which, as he said, he was not simply going to mansplain to us the forward, but to make his own original contributions to the themes that Carly has addressed in her forward and that which occur across the issue itself. And it also seemed that his comments were incredibly apt and suitable for this, the 50th anniversary year of the journal. He shared his history, his insights, and also a powerful message or two, which I think drew on those experiences. I couldn't fail to listen to him talking about the monitoring of police at the Empress Hotel in Redfern in the early 1970s without thinking of the role that the faculty's founding dean, Professor Hal Wushan, played in organising by busing new law students at the faculty in the first or second year of the faculty's history to Redfern for that express purpose. Some of which who said, I talk to these people now as alumni saying it was a profoundly shocking experience for them. They were very recent school graduates who had grown up in quite sheltered environments, but of course it totally transformed their lives and it changed how they thought about law. And of course that's something that we try to hang on to at UNSW. We don't want you necessarily to feel comfortable at all the time that you spend with us, but to be challenged and to see things, or hear things in classrooms or see things in the work that you do beyond the university's classrooms that really make you think and think about what you might do living a life of purpose in the law. The judge also talked about the role that he played, a very pivotal role in the establishment of the Redfern Legal Centre, which of course has ties to UNSW as well. Justice John Baston, who is an academic in the faculty, was also very heavily involved in the establishment of the Redfern Legal Centre. And there's a magnificent commemoration of Redfern by one of our former colleagues, Francis Gibson, which if you look at the index of that book, you can see that many names that are familiar from the history of UNSW law faculty and the contributions made to the incredible work of Redfern Legal Centre, where of course we still have a police powers clinic run primarily by Dr. Vicky Sentas. All of those kind of connections made me think about the words that everybody who studies and works in the law building goes past every day, and which we do repeat a lot because they are worth repeating, which is Hal's original message that a law school should have and communicate to its students a concern for those on whom the law bears harshly. And I'm very grateful to Cordella for selecting this theme of dynamics of power within criminal law, because it obviously speaks so very clearly to that concern. And the articles and papers which are assembled within the issue are also so very directly on that point. In that sense, the theme is one which I think really speaks to the very founding ideas of the law school and applies a very contemporary lens upon the problems and issues that we grapple with today. I have only had a chance to flip through the issue since arriving here tonight. I'm in no sense a criminal lawyer, but so much of this issue is so fascinating, and I can't wait to spend more time in reading through it. I really want to thank the judge for giving a personal history entwined with one which talks about the development of thought around policing, incarceration, and the role played by legal institutions and members of the legal profession. He gave us much to reflect on there, and in particular closed his remarks by suggesting that these things could not simply be assumed as safe. They are often, and particularly recently, have been put under considerable strain and attack, and there's much for us to do in resisting those things. So apart from everything else that was offered to us tonight by our guest speaker, was also a call to arms, really, to think about our purpose and the value of and the pride of wearing a label of a progressive lawyer. So I really want to thank him so much for giving us such rich thoughts to think on. I wanted to end by talking about something, just pointing out something very briefly in terms of a shame. I thought the interrelationship between criminal law, policing, and the institutions of the legal system are obviously themes that go through this issue. The thing around that interrelationship and this theme, of course, is that it's hard to envisage a time where those won't be relevant and they won't need our urgent attention. So I hope the Journal will consider making this a bit of a standing item. Recently, it was dismaying, when I think on those particular themes, to see the media attention, understandable interest in the fairly sensationalist trial of Erin Patterson in relation to the mushroom poisoning case, eclipse barely hours after the coronial inquiry report into Zachary Rolfe in the Northern Territory policing issues of race and First Nations people. So that those findings coming on the same day as the jury returned its verdict meant that the nation was deprived of a chance really to spend some time at least, even in our frantic news cycle, to really reflect on what the lessons of the Rolfe case might have shown us. There is, of course, much opportunity to embark on that reflection going forward, including academic. But we have a long, long way to go before these issues are ones where we might start to feel a degree of being comfortable. And as Judge Haesler has pointed out to us tonight, there is utility in discomfort. So thank you very much to him, and thank you to all of you.
Thank you, and that precedes tonight's speeches, and please feel free to hang around for an extra 20 minutes or so as we wrap up the rest of the event. Thank you for your time.